Welcome to Bracewell's Environmental Essentials webinar on updates on waters of the United States. My name's Daniel Pope, and I am an associate in our Austin office. I am joined today by two special guests, Ann Navaro, a partner in our DC office, and Sara Burgin, a partner in our Austin office. And you know that when the three of us get together, and we frequently get together, we usually talk about one thing, and that is WOTUS, the latest developments on waters of the United States. Been a busy couple of years for WOTUS, so I thought we'd set the table first by talking about where we are. As many of you know, and as Ann, Sara, and I have discussed frequently, the District of Arizona vacated the Trump-era Navigable Waters Protection Rule, or NWPR. The NWPR approached Clean Water Act jurisdiction using a set of categories, and if a particular water body was included, it would be jurisdictional. It also had numerous exclusions. The District of Arizona vacated that rule in early 2021, and we reverted to pre-2015 standards. You may also know that we are waiting on the Supreme Court's decision in Sackett versus EPA, and this is the second time that the Sacketts have been to the Supreme Court over issues related to EPA's enforcement of fill activity on their property. We call that Sackett 2, and we're looking for that opinion really any day now. The Biden administration also recently finalized another attempt at redefining waters of the United States with what we call the 2023 rule. Sara, what can you tell us about the 2023 rule?
Well, Daniel, rather than give you the list of categories of waters that you were mentioning before that are covered or excluded by the 2023 rule, I think it's more interesting to talk about what the agency describes as its intent in promulgating the 2023 rule, as they're described in the preamble. The agency stated in the preamble that the 2023 rule is founded on the familiar pre-2015 definition that has bounded the Clean Water Act's protections for decades, that has been codified multiple times, and that has been implemented by every administration in the last 45 years. The preamble also states that in developing the rule, the agencies considered, first, the text of the relevant provisions of the Clean Water Act and the statute as a whole, second, the scientific record, third, relevant United States Supreme Court case law, and the agency's experience and technical expertise after more than 45 years of implementing the long-standing pre-2015 regulations defining WOTUS. Now, being the cynic of the group, I think it's interesting that later in the preamble, the agencies explained that this rule that is codifying the pre-2015 regulation is informed by the best available science that is in significant part the 2015 connectivity report that was produced in conjunction with the 2015 rule by the Science Advisory Board, and that actually became a technical support document for the 2015 rule. With that transition thought, I will now turn the mic over to Ann, who will discuss what the challengers are saying about the 2023 rule versus the pre-2015 standards. Ann.
Thanks so much, Sara. So we're going to talk about the litigation in a minute because, of course, there's litigation. There's lots of litigation and lots of paper flying around various courts. But first, I want to turn to a little more practicality. So as Sara explained, the government characterizes the rule, the 2023 rule, as essentially a codification of the pre-2015 state of affairs. And of course, the folks who object to the rule, the litigants in various courts, do not agree. And so the question is it or isn't significantly different from the pre-2015 approach? And of course, this matters to you and your consultants and everybody who's trying to figure out how jurisdiction may or may not be changing much. The litigants say yes, that the rule changes jurisdiction meaningfully because it changes the test and it expands jurisdiction. And they put that into three categories. I think the first of which is particularly interesting. The rule includes now all interstate waters as a traditional navigable water, regardless of whether they are actually navigable. And it then includes other waters that are connected to those interstate waters using the significant nexus test. Now, in the final rule, the government says that in practice, the agencies have not asserted jurisdiction over these types of waters for decades. So that's clearly a category of water that is an expansion of jurisdiction under the 2023 rule. And then in another area where the challengers say the new rule is significantly different, of course, the rule codifies what the challengers say is a new and expanded version of the significant nexus test. And I want to point you all to a specific change in word that seems very small, but certainly has the potential to have great meaning. So the Supreme Court, Justice Kennedy described the significant nexus test as where waters either alone or in combination with similarly situated waters in the region significantly affect the chemical, physical, and biological integrity of another water. The 2023 rule changes that and to or. So instead of having to show the significant effect on chemical, physical, and biological integrity, the new rule would suggest that for jurisdictional purposes, you only need to show the effect on one of those three components. In addition, the challengers to the 2023 rule perceive significant changes in other aspects of the significant nexus test. For example, the rule codifies a list of 5 functions and 5 factors to be considered in evaluating whether a water has a significant nexus to a downstream traditional navigable water. There are 5 functions and 5 factors ranging from how those waters contribute to flow, how those waters assist with retention and attenuation of floodwaters and runoff. And it is certainly true that those factors in the rule are more specific and detailed than the factors we saw in the Rapanos guidance, which of course was used for quite a long time because those categories were more general. So those are the ways that challengers, the predominant ways that challengers have alleged that the new rule is actually quite different from the pre-2015 version, which of course they also argue was unlawful in any event, which Sara is going to explain.
One of the things, I guess at this point, I was just going to talk about significant nexus in general and the scope of it and how so many of the problems that we're seeing are sort of expansion in the scope of significant nexus, similar to what Anne just spoke to. And in the context of the challenges and the rule, I wanted to point to some specific language in Justice Scalia's discussion of Justice Kennedy's concurring opinion in the Rapanos decision. And I think that this language explains the crux of the issues that I have always had with the legality of the significant nexus test. Obviously, I know that it's a concurring opinion, and with Marks, it's part of the decision. But I found Scalia's statements really interesting, and I wanted to read them to you. So Scalia states, only by ignoring the text of the statute and by assuming that the phrase of swank, significant nexus, can properly be interpreted in isolation from the text, does Justice Kennedy reach the conclusion he has arrived at. Instead of limiting its meaning by reference to the text he was applying, he purports to do so by reference to what he calls the purpose of the statute. Its purpose is to clean up the waters of the United States, and therefore anything that might, quote, significantly affect the purity of those waters bears a significant nexus to those waters. And thus, he never really says this, but the text of the statute demands that he means it. It is those waters. So obviously, he's added to the definition of waters of the U.S., waters that have the potential to affect waters of the U.S. Scalia goes on to say, this is a familiar tactic of substituting the purpose of the statute for its text, freeing the court to write a different statute that achieves the same purpose. To begin with, as we have discussed earlier, clean water is not the only purpose of the statute. So is the preservation of primary state responsibility for ordinary land use decisions. Justice Kennedy's text takes no account of this purpose. More fundamentally, however, the text simply rewrites the statute using, for that purpose, the gimmick of significant nexus. So with that, I will turn it back over to Daniel.
Every time I think about Rapanos, I start to get a headache because we have a plurality opinion and a concurring opinion and a dissent. And now that pain has started to feel more familiar. And I'm always wondering when we are going to have something replace Rapanos. And the way you start is you start at the district court. We've seen a lot of litigation over the new 2023 rule, Sara. We've seen some in Texas. We've seen litigation in Kentucky, and we have seen litigation in North Dakota. We're all going to talk about that. Sara, why don't you start us off with what we've seen in the Texas case so far?
Happy to. So the Texas case is cleverly styled Texas et al. Versus EPA. It started as two complaints that have been consolidated into the current decision. So the plaintiffs are two states, Texas and Idaho, and then there are 18 national trade associations. The key arguments in the Texas case, one is Chevron deference. And Daniel, you're going to talk about that in a few minutes when I finish this discussion because it basically is involved in all of the cases.
That's right.
Okay, so the second argument is assuming that Kennedy's significant text is a valid standard, the 2023 rule expands the test materially beyond the standard articulated in Rapanos. That was one of the comments Ann made a minute ago. And then third, the 2023 rule unlawfully expands coverage to non-navigable interstate waters that Ann also mentioned. So all of the plaintiffs requested preliminary injunction, and a preliminary injunction was granted to Texas and Idaho on March 19th, 2023. No injunctive relief was granted to the associations apart from that granted to the two states. I wanted to mention that the court found that the states showed irreparable harm, but the associations did not. The states used the following to demonstrate harm. First, the rule intruded upon state sovereignty over intrastate land and waters. Second, the states will incur unrecoverable compliance costs that will unnecessarily burden them. And third, the states provided detailed declarations of specific anticipated costs, monetary and otherwise, of compliance with the rule. So that will come up later, I think, in terms of what's happening with the other cases. Just briefly, the status is that the judge held a pretrial conference on April 5th, and there is a scheduling conference to be held on July 14th for the substantive case. And I'll turn it back to you, Daniel, to talk about Chevron deference.
Thanks, Sara. One of the things that I thought was really interesting about the opinion in this preliminary injunction case in Texas was that the court concluded that Chevron deference didn't apply to EPA's interpretation of the Clean Water Act, at least in this respect. Citing Fifth Circuit precedents, the court concluded that Chevron deference didn't apply based on rule of lenity grounds. Now, that's something we don't talk about a lot in environmental law. It's something we don't talk about too frequently in administrative law. But the rule of lenity is a canon of construction that basically says that when you have a statute that could be used to impose criminal liability on an individual, on a company, and there's ambiguity about the scope of the statutory language that makes the conduct an offense, you're going to interpret that ambiguity, or you're going to resolve that ambiguity in favor of the criminally accused. And because the jurisdiction of the Clean Water Act is relevant to the criminal provisions of the Clean Water Act, the judge concluded that Chevron deference couldn't apply. So it's really interesting. We're going to see that come up in other cases, but I hadn't noticed that before. And I thought it was worth flagging as an interesting approach. We've talked a few times on this webinar series about the role of deference to administrative agencies. And we've always kind of wondered, where's Chevron in all this? Is Chevron going away? That's been one of the big topics of discussion about the current makeup of the Supreme Court. And it may be that Chevron doesn't go away. It just gets sidelined. But obviously, that's a bigger question than what we have before us today. And can you tell us about what is happening in the Bluegrass State?
Yes, I can, Daniel. Thank you for asking. So the second set of cases was filed in the Eastern District of Kentucky. There are two combined cases, just like in Texas. There's the lead case brought by the Commonwealth of Kentucky, and a second case brought by a number of associations, including the Kentucky Chamber of Commerce and the U.S. Chamber of Commerce. The arguments in the Kentucky litigation certainly parallel the arguments we see in the Texas litigation. And I wanted to highlight just a few of those. And I think all of these arguments kind of explain some of the basis for Daniel's headache, because they all reflect concerns about the vagueness of the definition, the difficulty of the definition, the expansion of jurisdiction, those types of arguments. So in the Kentucky case, the plaintiffs are arguing any number of things. But one of the things I wanted to flag is the argument that the 2023 rule creates a definition of waters of the U.S. that is subjective and applies on a case-by-case basis and may result in similar waters being treated differently. And I think if you study the definition, in my view, you will recognize the merit of that allegation because of the fairly complex scientific analysis that the definition of significant nexus and the other elements of the rule anticipates, and the basic reality that Corps of Engineers districts, who do most of the jurisdictional determinations, approach things differently. People are different, regulators are different, they have different experiences, they all have different perspectives. And so we all know that things are not always consistent between core districts. Sometimes that's frustrating, sometimes it's understandable. But I think jurisdiction is no different. And the Kentucky case certainly latches on to that as a concern. In the Kentucky case, the litigants are also arguing due process, that the rule imposes civil and criminal penalties on regulated entities without adequate notice of what's jurisdictional because of the difficulty of determining that in any particular case. Of course, litigants in Kentucky also raise the now favorite major questions doctrine after West Virginia EPA, arguing that the scope of water subject to the Clean Water Act is of such vast economic and political significance that broadening jurisdiction without clear black and white direction of the test violates the major question doctrine, and that the Clean Water Act does not authorize that. They also argue that the 2023 final rule is not a logical outgrowth of the draft. And I want to flag one thing here because it is meaningful to a consultant or folks in-house who are trying to figure out what is jurisdictional. Of course, the famous Rapanos significant nexus test suggests that the measure of effects is whether they significantly affect, whether those waters alone or in combination significantly affect the chemical, physical, and biological integrity of another water. Significantly affect has now been interpreted as materially influencing a traditional navigable water. And so the litigants in the Kentucky case, and I believe in the others, are arguing that that is a meaningful change from the draft rule and yet provides another example of the agencies loosening the standards around jurisdiction. Now, what's happened in Kentucky is quite interesting to me as a fan of APA litigation. The judge in Kentucky denied a motion for preliminary injunction that sought to enjoin implementation of the rule, and then dismissed the case sua sponte on March 31st based on standing grounds. The judge found that neither the Commonwealth of Kentucky nor the various trade associations actually had standing to challenge the rule. And even though the government had not moved to dismiss the case, at least as of yet, the judge decided to go ahead and do that on his own. That was, I think, a surprise to a lot of observers, including myself. And both the Commonwealth of Kentucky and the trade associations have filed an emergency motion for stay pending appeal of that decision. And I expect that they will go up to the Sixth Circuit regardless of the outcome of that motion. And of course, the Commonwealth of Kentucky is arguing quite strenuously that as a sovereign, as a regulator, as a landowner, that the state has shown standing. And it is certainly true that there is meaningful Supreme Court precedent that stands for the proposition that there is a somewhat looser standing inquiry when it comes to state interests. So it's an interesting example, perhaps, of judicial restraint in a case where a judge decided he did not have a place to resolve this meaningful question because of lack of standing. But I expect there to be significant additional litigation around that question. And Daniel, I will hand it over to you to talk about our third case.
Thank you, Anne. And, we've already talked amongst ourselves that this next case, West Virginia versus EPA, which has actually been filed in North Dakota, may be confusing to keep track of. And on top of that, you just referenced the major questions doctrine, which was another Supreme Court decision titled, West Virginia versus EPA. So I don't know who I suppose there's a suggestion box at the district courthouse in North Dakota, and I may have to drive up there and leave a little note. But in this case, we have 23 state plaintiffs, along with quite an array of interveners and several tribes and trade groups. And Anne and Sara both covered a lot of the key arguments that are involved in these cases. These cases, they do overlap substantially. One thing West Virginia is really emphasizing is that key jurisdictional terms like similarly situated waters are impermissibly vague. It may be one thing for Justice Kennedy to use the phrase in his concurring opinion in Rapanos. It's another thing when an agency uses that same language in trying to set forth the limits of Clean Water Act jurisdiction. As we've also seen, these parties here are arguing that the 2023 rule ignores the navigability requirement in the Clean Water Act. And that's been disputed in nearly every case that has gone to the Supreme Court, at least in some capacity previously. And we'll see what happens if one of these cases makes it all the way to the big dance. We'll see what the Supreme Court does, again, with that sort of navigability and fact requirement. Is that a requirement in the Clean Water Act? Is it not? We can expect those arguments to be reprised moving forward. We're also seeing the plaintiffs in West Virginia try to sideline Chevron, as I just talked about in the context of the Texas case. And unlike these two cases, in West Virginia, in the North Dakota case, we are seeing that the plaintiffs have requested a nationwide injunction to stop the rule from going into effect throughout the country. We'll see if they get that relief. That's always very dramatic when it happens. But if you'll recall, at the end of the major cases dealing with the 2015 rule, we had a national quilt of which regulations applied where. And one state may have followed the 2015 rule, and another state may be following the older framework, right? So we'll see. I know that it's especially concerning to businesses with a larger geographic footprint that may be operating in different jurisdictions. Where we are with the North Dakota case is that the plaintiffs moved for a preliminary injunction on March 29th. We are expecting to see responses at the end of April, and we'll see replies to those in the middle of May. Maybe a decision at the end of May. So that's where that case is. And of course, we have quite a bit coming around the bend. We mentioned at the top of this webinar that we're still waiting for the Supreme Court's opinion in Sackett 2. And that case involves the appropriate test for determining the jurisdictional status of wetlands. This is actually I think we started the current Supreme Court term with this case. So it was one of the first cases argued in this term. We're still waiting on the opinion. As it takes longer for opinions to come out, you start to wonder, are they going to be more significant? So we're obviously going to be watching for that. The Biden administration has still indicated that it's going to be conducting a phase 2 rulemaking to add to, presumably, types of waters that are covered by the Clean Water Act. It's anticipating that we'll publish a notice of proposed rulemaking in November 2023 with a final rule by July 2024. We'll see if that happens. The decision in West Virginia versus EPA, with so many states involved, you saw that there were 23 states involved. It'll be significant for a second rulemaking, as will any decisions coming out of Sackett. But it's one thing to talk about litigation and to watch what states and trade associations are arguing. It's another thing to understand what's going on and apply it to your own project. So, Anne, can we spend a little time thinking about a couple of practical takeaways from what we've covered? Like, if I'm at a company, I'm wondering, okay, well, what do I do next in light of all of this litigation, in light of all of the implications of that litigation, and then possible rulemaking? So what are some of your best practices when these legal frameworks are in flux?
Well, first of all, having a big jar of Advil on the desk is definitely one of my best practices. It's confusing, but it's been confusing and frustrating, I think, for a long time. I mean, back to the beginning of the 1986 regulations. things have been contested, in flux, subject of litigation, rulemakings. As a practical matter, as we sit here today, the new rule is in effect in all states except for Idaho and Texas. And in those states, the pre-2015 structure is in place, which is the 1986 regulations as interpreted by the Rapanos guidance. Now, how that is different as between Idaho and Texas and the rest of the states currently, I think is very dependent on the districts, how they approach things, on your consultants, how your consultants have always approached things and continue to approach things. I've heard consultants in some parts of the country, say that they're not sure the new rule will make a meaningful difference where they are. Now it might in parts of the country with different climates and different geographic features, or maybe they're just overly optimistic. So the practical effect right now is sort of status quo in Idaho and Texas, certainly. And then in the rest of the country, the new rule is in effect. And I think it's going to be a case-by-case situation as to how that plays out. And folks who have in-house expertise and excellent consultants, I know will be looking closely at jurisdiction and whether it may change for them under this new rule. I expect it will in some circumstances. The other thing I wanted to mention is the role of approved jurisdictional determinations. So those are AJDs, and I'm sure as the audience knows, those are basically formal determinations of jurisdiction that the Corps of Engineers will issue upon request. And those have become quite controversial since the Trump administration rule was vacated, because the Corps and EPA have had a long-standing policy that those are good for 5 years and that you can rely on them. The current administration, my perception was very uncomfortable allowing folks to rely on AJDs that had been issued under the Trump rule because of the narrowing of jurisdiction relative to the prior structure. And so issued guidance that I think was not clear to a lot of folks. And they basically restate that guidance in the final 2023 rule in the preamble and remind folks that AJDs that were issued under the prior regime, under the Trump administration rule, will not be relied on by the Corps in making new permit decisions, and that they can be revisited based on new information. At the same time, the government has stated that AJDs are still valid for 5 years. So there are a couple of very high-profile cases where opponents of projects are arguing that AJDs issued under the Trump administration are allowing people to fill waters of the U.S. without regulatory oversight under the current regime. And so that's an issue where if folks still have AJDs from the previous rule, that, they just should be paying a little attention to, because it's a little bit of an uncertain area.
And I would add as another very practical takeaway, if you are concerned about staying on top of these developments as they happen, why don't you go to Bracewell's homepage, bracewell.com, scroll to the bottom, click on a big red button that says Stay Connected. I can almost guarantee that Anne, Sara, and I will be putting together some additional material in the form of client alerts or even presentations where we discuss what's going on with WOTUS. I don't think this is the last time the three of us have gotten together to have a conversation about the geographic reach of the Clean Water Act. So go ahead and sign up for those. We'll also be covering any late-breaking developments in federal regulation at our seminar in Houston. That's going to be on May 9th. Check your inbox for an invitation, which will be coming soon. And we hope to see you there. Thank you for spending a little bit of time with us as we break down some of these latest developments in WOTUS, and we'll talk to you soon.